Good morning, everyone, and thank you for your patience. We're pretty much starting when we normally start, giving everyone an opportunity who may have trouble to join in. The hour having reached 11 a.m., 11:04 Eastern Time, I would like to welcome you all to our August 7th, 2024 public briefing in the North Carolina Advisory Committee to the United States Commission on Civil Rights. I am Olga Morgan Wright, your chair of the committee. Before we get started, I would like to remind everyone that this meeting is being recorded, and I will begin with the roll call. Daniel Bose, Pearl Burris Floyd, Travis Cook, Christopher Duggan is out today. Marcus Gatson,
Here.
thank you. Stephen Green,
Here.
thank you. Jonathan Guzet,
Here.
thank you. Jennifer Lechner,
I'm present.
thank you. Donna Oldham,
Present.
thank you. Catherine Reed,
I'm present.
thank you. Mercedes Rustucha,
I'm here.
thank you. And Gregory Wallace is out today as well. The United States Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws. In all 50 states, the District of Columbia, and the U.S. territories, an advisory committee to the commission has been established, and they are made up of reasonable persons who serve without compensation to advise the commission on relevant information concerning their respective jurisdictions. Today is our third briefing where we will hear testimony from the Policy and Governance panel. Given that we have a lot to cover today, and out of respect to our guests, I want to note that we will abide strictly to our agenda. Panelists will have 10 to 12 minutes for prepared remarks. I'll provide each panelist a 2-minute warning when their time is almost up. After each panelist has presented, we will begin Q&A session. Following Q&A, we will have a public comment period. Displayed on the screen are audio and visual tips during public comment. Members of the public have up to 3 minutes for their comment. Members of the public should kindly note that the public comment section is intended for remarks on our study and is not meant to be a Q&A with committee members or panelists. A timer will be made visible on the screen so that speakers will know how long they have. Speakers will be notified when their time is up. I reserve the right to provide warnings if a speaker is over time and ask staff to mute the speaker. We ask that everyone respect the time allotted and end their remarks when the 3 minutes run out, as to give others a chance to speak. We will need to give a verbal 1-minute warning for any public commenters joining by phone, as they are not able to see the timer. For all participants, if for any reason it would be helpful for us to provide you a 1-minute warning, please let us know when we call your name. Though some of the statements made today may be controversial, we want to ensure that all guests today do not defame or degrade any person or any organization. If a specific person or organization is named in a potentially defamatory manner, they will be provided with an opportunity to respond, and this response will be part of the public record. As chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand via the following process. I will remind the commenter that we do not accept defamatory, degrading comments and will reach out to the impacted person for a response. If the statement continues in the same manner, I will give the person a warning that we will hard mute them if they continue, and the commenter may be hard muted if needed. Later in the meeting, we will take a short break, then proceed to the committee business meeting, with members of the public are welcome to stay on for. Members, please plan to stay as we will discuss next steps to this project. At the outset, I want to remind everyone present of the ground rules. This is a public meeting and remarks will be recorded and transcribed for the public record. We have a very full schedule within time that is available to us. After hearing from all panelists today, committee members will be called on using the roll call list. Committee members are limited to one question and a follow-up as time allows. I will circle back around for a second round of questioning again if time allows. Committee members are asked to focus on a question and not sharing comments or their own opinions on the topic. To the extent possible, please direct your question to one panelist at a time. At the second round of questioning, committee members are asked to use the raise hand function in Zoom to express their interest in asking a question of one or all panelists. I will ask committee members in the order that their hand is raised. Please note that you will have the opportunity to submit follow-up questions to panelists via staff after today's meeting. To accommodate persons who are not on the agenda but wish to make comments, we will ask for public comments toward the end of today's meeting. 3 minutes will be allowed per speaker. And again, please note that this time is for comments directed to the committee only and not for a Q&A with panelists. We will strive to accommodate as many members of the public as time allows. If you have previously shared comments, we may prioritize those who have not yet had the opportunity to speak. Thank you for your understanding and cooperation. Please note that we are required to obtain legal names of anyone providing public comment, as required by the Federal Advisory Committee Act and its regulation 41 CFR 102-3.165. The chair must ensure that detailed minutes of meetings are kept, and those meetings must include a list of persons who are present at the meeting, including members of the public who present oral or written comment. Please contact staff at lschiller@usccr.gov if there is an error in your name and you need it to appear correctly in the public record for today's meeting. In addition, written statements related to today's briefing may be submitted by September 23rd, 2024 to Liliana Schiller at lschiller@usccr.gov for inclusion in the public record. Based on these proceedings, the committee will prepare a report to the United States Commission on Civil Rights detailing findings and recommendations for addressing this issue of national importance. Drafts will be available for public review, and we are grateful to all speakers for their willingness to share their experiences with us today. Today, we are scheduled to hear from 3 panelists. Once all of these panelists have finished their testimonies, we will have a Q&A session. Panelists are invited to stay for the remainder of the meeting as long as you're able. Following public comment, we will have a short committee business meeting open to the public. Our first speaker for today, Wendy Sotolongo. She is a parent defender for the Office of Parent Defender, North Carolina Indigent Defense Services. You have the floor.
Thank you. As you said, my name is Wendy Sotolongo. I'm an attorney who has spent almost 35 years practicing abuse, neglect, and dependency, or A&D law in North Carolina. Early in my career, I represented a county department of social services. Then I represented children removed from their homes as their attorney advocate. I strongly believed I was helping children in those jobs, but after 16 years, I saw no improvement in the outcomes for children and families caught up in the system. I became convinced that if we truly want to help children, we must support their parents. For the past 18 years, I've worked at Indigent Defense Services of North Carolina. I run the Office of the Parent Defender, which is a statewide public defender office dedicated to supporting attorneys who represent parents in A&D cases at the trial level. We also represent parents on appeal. I want to thank this committee for holding these briefings and especially for listening to the experience and perspective of those who have been impacted by the child welfare system. I agree with panelists and public who envision a different future. While child safety is non-negotiable, we know that most children in the system are there because of neglect, not abuse. Data for 2022 shows that 74.3% of the substantiations were for neglect. What if those families labeled neglectful were offered support and resources they need instead of an investigation? What would it look like if each community came together and created a family well-being and support system to prevent traumatic investigations and family separation? We've seen it work in Marietta, Georgia, with Sarah Winograd's Together with Families. It can be done. And in this future, government agencies will work with their community partners through direct subsidies and meaningful services to address families' needs. But while we work toward this vision, we must also work to reduce the harm that is caused by family separation. I'm an attorney, and rightly or wrongly, my remarks are focused on needed changes to our legal system here in North Carolina. In the interest of time, I'll not cite the studies or statutes I mentioned, but they have been included in my written testimony. I have 7 recommendations. 1, North Carolina should study its mandated reporting statute. North Carolina requires that anyone who has cause to suspect that any juvenile is abused, neglected, or dependent make a report to the director of the Department of Social Services. One study shows that only 17% of the reports received are substantiated for abuse, neglect, or dependency. Clearly, there's a lack of understanding and training around what should be reported, which is leading to over-reporting by mandated reporters in unnecessary investigations. North Carolina should study whether its universal mandated reporting law is keeping children safe and whether alternatives may be more effective in identifying children at risk of harm. Number 2, parents should have access to attorneys during a Child Protective Services investigation. In North Carolina, the right to a court-appointed attorney does not attach until a petition alleging abuse, neglect, or dependency is filed. Unfortunately, by the time a petition has been filed, the parent's child has often been removed from the home, creating long-lasting trauma for the family. Providing legal representation before a petition is filed is a proven way to help stabilize families and prevent removal. Pre-petition or preventive legal representation programs offer parents legal and social work advocacy to address matters such as orders of protection, safe and affordable housing, public benefits, guardianship, special education needs, and other issues that help prevent child maltreatment. North Carolina should amend its statute to ensure parents have access to quality legal representation during a CPS investigation, and this right should include holistic representation and support services. Number 3, North Carolina should amend its statutes that address removal of a child from a parent to require the court to address the trauma of removal and the steps taken to mitigate the trauma. Casey Families Program states that, and I quote, investigation, removal, and placement are sometimes necessary to protect children from abuse and neglect. We must recognize, however, that they are not typically viewed or experienced as positive or protective by children and families, but rather as adverse childhood experiences. The field increasingly recognizes that investigation, removal, and placement often are traumatic events in and of themselves for all involved. Consideration of the very real effects of these actions must be balanced with the child's risk of harm at home when making decisions about how to best engage with the child and family. North Carolina should incorporate consideration of the emotional and psychological harms of removal in its statutes authorizing removal and require CPS to detail its plan to mitigate the traumatic effects. Number 4, North Carolina must fundamentally change the culture of parent-child contact after removal. I fully support the comments of Professor Laura Matthews-Jolly when she testified before you on July 12th. To quote her, frequent, meaningful visitation reduces the amount of time children spend in the foster system, increases the likelihood of family unification, both achieved and sustained, and results in multiple positive outcomes for children, even when family reunification does not occur. North Carolina should amend its statutes that address visitation. Right now, we have a presumption of 1 hour supervised per week, which is completely inadequate to maintain the bonds between parents and children. We must establish a presumption of weekly, multi-hour, and unsupervised visitation unless it is proven contrary to the safety of the child. Number 5, North Carolina should pass the provision of Senate Bill 625 to allow children to maintain ties with their family after adoption. Termination of parental rights is rightly termed the death penalty of civil cases. Recent decades has seen a strong trend toward adoptions that give parents some right to have contact with or receive information about their child after adoption. Frequently referred to as open adoptions, these arrangements contrast to the standard closed adoptions of the past, in which parents retain no rights and often knew little about their child's adoptive family. The number of completely closed adoptions has decreased substantially nationwide. Older children represent a growing proportion of children adopted through a Department of Social Services, and these children often have significant attachments to their parents and would benefit from some form of connection after adoption. Senate Bill 625 was a bipartisan bill that passed with overwhelming support from the North Carolina Senate, and it permits an enforceable agreement between a parent and an adoptive parent to allow a child to have ongoing contact with their parent after adoption. The North Carolina House should pass this bill. Number 6, we need to increase the pay for attorneys providing legal services to parents in abuse, neglect, dependency cases. Rylan's law fails to address the need for high-quality legal representation for parents in abuse, neglect, dependency cases. 48 of North Carolina's 100 counties qualify as a legal desert. A legal desert is an area where there's less than one lawyer for every 1,000 residents. There are even fewer lawyers in these counties that represent indigent parents as their court-appointed attorney. As fewer attorneys are available to take court-appointed cases, caseloads grow and quality suffers. One of the reasons attorneys are leaving is the low rate of pay. 13 years ago, in 2011, attorneys were paid $75 an hour to represent parents in abuse, neglect, dependency cases. That year, in 2011, the North Carolina legislature slashed IDS's budget, which required the rates to be cut to $55 an hour to represent parents. Good attorneys who long felt an obligation to serve justice and protect a parent's constitutional rights were forced to leave parent defense. They simply couldn't afford to do the work any longer. If the rate of $75 an hour in 2011 had not been cut and had been increased to meet inflation, that rate would currently be $107 per hour. Instead, it is $65 an hour due to a small bump we were able to implement in 2022. I know that $65 an hour can sound like a lot of money, but you must remember that before a dime goes into an attorney's pocket, they have to pay for rent, self-employment taxes, malpractice insurance, office equipment, office expenses, telephone, internet, bar dues, legal research tools, and any staff. Many lawyers also have student loans that they're repaying. IDS did a study that found the average overhead costs for non-optional items averaged over $45 an hour, which significantly cuts into the $65 an hour they are paid. Number 7, we must provide interdisciplinary legal representation to all parents with an abuse, neglect, and dependency case. Attorneys need resources such as defense social workers and parent partners to provide holistic representation to their clients. It is well established that interdisciplinary representation significantly improves outcomes for families with an abuse, neglect, dependency case. One of the more recent studies provides evidence that interdisciplinary parent representation is an effective intervention and promotes faster and safer permanency for children in foster care. With support from multiple partners, including North Carolina's Court Improvement Program and our state DSS agency, my office began an interdisciplinary program in 2022. Attorneys participating in the program apply for the services of an independent and experienced social worker to work with the attorney in the representation of a client. So far, we're only in 6.
You have 2-minute warning. Thank you.
Thank you. So far, we're only in 6 of North Carolina's 100 counties, but we're seeing very positive results. And to end, I'd like to share an email exchange between my office, the social worker, and an attorney regarding a case. From the social worker, she writes, I have a client whose son has been in custody for many years. I was assigned the case in February of 2023. At that time, my client had completed her case plan, but had not seen her son in almost a year. We were quickly able to get visits set back up. Meanwhile, the child was struggling in and out of placements, not in services, and had not been in school for almost a year. Last week, he ran away from DSS placement and sought out his mother. The attorney was able to work out a consent order that allowed this child and mother to reside together, and today in court, a trial home placement was authorized. Long story short, in less than 6 months, of an interdisciplinary representation, this mother went from not seeing her son in almost a year to having him back in her home full-time after 6 years of trying on her own. The attorney followed up saying, I totally concur. I also got this case 6 months ago when the former attorney resigned. The client was very wary of the system. I doubt she had any faith in me as her newly assigned attorney. The IPR program is able to assist the client and me to achieve this result. The social worker developed a trusting relationship with the client, provided expertise about services not being provided. She even pushed me to file motions when she felt the department needed a legal nudge. I confess I was extremely skeptical of the value of the interdisciplinary representation. However, I now request a social worker in almost every case. Their value is tremendous, and I hope we'll continue to have this resource available to our clients. In conclusion, there are approximately 11,500 children in foster care in North Carolina. Every one of those children and their parents deserves to have an attorney that is adequately compensated and has access to resources such as social workers, parent peer advocates, investigators, interpreters, and expert witnesses. Thank you so much for your time and your attention to this critically important issue.
Thank you so much for your remarks, and we will now move on to Senator Lisa Grafstein, who represents District 13 for the North Carolina State Senate. Senator Grafstein, you have the floor.
So much, and thank you for the invitation to be here. My name is Lisa Grafstein. I serve in the North Carolina Senate representing Senate District 13, which is part of Wake County. I was invited to be here and am here in my legislative capacity. However, my comments and perspective today are informed by my work as an attorney for disability rights in North Carolina, which is the protection and advocacy agency for people with disabilities in the state. We hear from people with disabilities across the state who have a variety of issues related to their disability. And in recent years, that has included individuals involved in the Child Protective Services system. I want to be clear from the outset that I'm not an expert on these issues in either capacity. And I want to thank the committee for convening these discussions. I'm most interested in hearing from others with daily experience of the issues being addressed. What I hope to offer is the perspective of someone who has the benefit of two very different windows into the system. From the legislative point of view, I want to address the problem of state funding and the difficulty of meaningful oversight of complex systems. At the other end of the spectrum, I want to touch on the ways in which individual stories and experiences should inform policy level decisions. I think it's important that we start with funding. In short, and particularly I want to reflect also on Ms. Sotolongo's point about attorneys' fees and the way that that is an important piece of the system that's missing right now and is certainly a funding issue. But in short, the funding for a whole range of services in our government right now is not adequate, and we are going in the wrong direction. There are dramatic staffing shortages in virtually every corner of state government. A significant and obvious and persistent reason for these staffing shortages is the fact that we simply don't pay workers enough to do the jobs that we need filled. And of course, that is throughout the system, including agencies that touch on DSS work. In state agencies, we have vacancy rates from 25 to 40%, and of course, lack of funding to counties for DSS offices creates a similar dynamic there. The problem isn't that we have a lack of funds at the state level. We have the capacity for adequate revenue, and we have substantial existing reserves. The problem is that we have systems in our state that are buckling under the weight of chronic underfunding, and where you're in the process of reducing our revenue even further. We have on the books right now an ongoing reduction in the corporate income tax, which in the year 2030 will go down to zero. This will cost the state $2 billion a year, billion with a B. A similar process as it relates to the wealthiest among us will reduce our revenues even more in the coming years. Nonpartisan General Assembly staff project that we will have a structural deficit in our budget as early as 2026. That means we will be unable to maintain even level funding going forward in a whole range of services that are provided by the state. At that point, we may see efforts to try to make even further cuts to the state budget. And this will be, of course, exacerbated for many county DSSs by the fact that many counties right now currently are making up funding gaps based on legislative budget cuts. And those gaps will continue to need to be filled by counties for things like education and other areas. I raise all this to say that even as we gather to talk about how to better serve the children of North Carolina, there are policy decisions being implemented that are moving us in the wrong direction. And of course, that has implications for whether the system is set up to protect people's civil rights. So that's the backdrop, and I hope underscores the need to maintain visibility of the harms being caused when we don't adequately fund the systems that are meant to protect people. I want to turn now to the oversight role of the General Assembly. I'm in my first term in the legislature, and what I have learned very quickly in the last year and a half is that in many different contexts, we as legislators receive information at a very high or aggregate level. Most often, the information we rely on comes from agencies which have to weigh a lot of factors in deciding how much to share and what to emphasize. That has obvious limitations in many ways. In the CPS context, the dynamic is magnified by the fact that we have 100 counties operating 100 different systems, funded in large part by county governments with an overlay of oversight at the state agency level. As I understand Rylan's law, it is meant to address some of this disconnection through the use of regional oversight. I think it's critical, though, that we not simply create another layer in the existing system, but use the opportunity to ensure that oversight and information gathering is not just quantitative data gathering. Data is important. We need to develop, though, an honest and robust set of information about what's going on in the system, what's going right, what's going wrong as a whole, and in specific pockets. That is especially true in the context of the civil rights of people touched by the CPS system. Data can tell us that there are disparities, but not necessarily pinpoint what is happening on the ground that is driving the data. And frankly, the data doesn't always capture the kinds of disparities we see in the disability context, which I will touch on a little more later. You may have heard the expression that culture eats strategy for lunch. Culture eats strategy for lunch, right? You can have a great strategy. What I understand this to mean is that the culture of an organization has much more to do with the outcomes that are produced in that organization than any well thought out high level plans. And that is my concern about the implementation of Rylan's law. We need to assess culture at the local level, ensuring not just compliance, but alignment with values. And one of those values, from my perspective, is addressing bias, including but not limited to in the context of people with disabilities. So in that context, we see parents with disabilities who are viewed as less capable of caring for their children or presumed incapable of learning new parenting skills. I will also mention, as an aside, that there's a correlation between disability and poverty that I think is also at play here. And we also see parents of children who have disabilities who have faced involvement with CPS, particularly those, again, who struggle financially, where the family as a whole and the child with a disability in particular would have been better served by the provision of disability-related services to the child rather than removal. The word neglect, as I think we all know, is sometimes just another word for poverty. There are any number of examples of parents who have been unable to access mental health services for their children, who in desperation take their child to an emergency department only to have CPS called because they quote unquote abandoned their child. It's critical that we understand these cases as being about gaps in our behavioral health system rather than neglect. In a system that doesn't have enough resources, including foster families, we would do well to use those resources wisely by supporting families to stay together where possible. And of course, that's also just the right thing to do for all involved. There are, as I mentioned, a lot of challenges being a parent with a disability, and there are challenges raising a child with a disability, which I can speak to personally as the mother of a son with autism. But too often those challenges are met not with support and an assumption of competence, again, particularly when we're dealing with folks who have low incomes. But those challenges are met with a presumption that a child is better off being removed or placed in an institutional setting. We know, for example, that approximately half of the children placed in psychiatric residential treatment facilities are children in foster care. And many of those children are sent to out-of-state facilities where they have little to no contact with their home communities. To Ms. Sotolongo's point about trauma of removal, we regularly see children removed and placed in situations that are no less harmful and sometimes dramatically more harmful than the situations they were in. And I agree with her that there should be consideration with regard to that before removal is considered. Where is the child going, not just where are they coming from? We know anecdotally that children removed from their home due to their own disability or a parent's disability often face being institutionalized rather than receiving kinship or community placement. Again, I want to emphasize that individual and anecdotal information has to be accounted for. It's not accurate or helpful to treat individual cases as anomalies. We have to understand them as symptoms of something gone wrong, often with the culture even more than with quantitative systems. I would like to see regional oversight and oversight at the state level that gets at the reasons why we have some of the individual and group outcomes that we have so that we can correct them. Changing policies, writing memos, gathering data, these are necessary, but they are not sufficient to fix what is ailing our system right now. Thank you all again very much for creating this opportunity. I have found it all very educational, and I look forward to hearing more comments from others. And thank you for your time.
Thank you very much for your comments. Our next speaker, I would like to introduce Lisa Tucker Cauley, Senior Director for Child, Family, and Adult Services for the North Carolina Department of Health and Human Services. Ms. Tucker Cauley, you have the floor.
Thank you so much. And I am pleased to be here to speak to the panel. I am with the Division of Health of Social Services with the Department of Health and Human Services. And I come to this job with a long number of years in county work in child welfare. And one of the reasons why I left a job in a large, well-resourced county was concern over consistency across the state and the opportunity that Rylan's law offered to be able to have consistency across the state. As you can tell from my voice, I'm from Eastern North Carolina, and so I am well aware of what child welfare looks like in many parts of the state, especially the East. So let's go to the next slide. I'm going to go over briefly the child welfare system as it stands now, so there's some common understanding of what exists. And then I'm going to talk a little bit about what Rylan's law, the impact of Rylan's law, and where we are today with some challenges. What you have before you for your reference is a trajectory of what a family experiences with the child welfare system. I'm not going to stay here long, but I just want to point out that there are, when you look at reports that come in, when reports come into county departments of social services, there's an expectation that they be screened. And at that first look, it's a look at the legal definition. Does what the callers say, does that meet the legal definition of abuse, neglect, or dependency? If it doesn't, that call is screened out. If it does, a family receives a visit from a child welfare worker, and they make a determination, work with the family, look at are there services, and make a determination, are children abused, neglected, or dependent? If not, the case is closed. If so, they can put a plan in place and work with the family and open them up for in-home services. And that's the place where the prevention, if you are in the child welfare system, prevention happens there and in that assessment room. So if you look at if you look at roughly 20% of children that receive a CPS assessment are served in in-home services. If workers cannot work with families to figure out how to protect a child using community resources, using a family support network, then a small percentage, typically 4 or 5% of the children reported would enter foster care. And then when you look at children in foster care, most children in foster care live in family homes, with kinship being 24% of the population of children live in kinship care homes. North Carolina hopes to increase that, and we'll talk about that a little bit more. And then the last list is the last column is really how do children leave the foster care system? The majority, when you look at the exits, the primary reason for exit is reunification. We're going to talk about how that needs to happen sooner and a little bit later. And then the next would be adoption with family or adoption with foster parents. So let's go quick to the next slide. This slide is just for reference. So this is some of the decision-making points in child welfare as you think about, and as the committee really thinks through how the child welfare system, how it exists now, and really what happens and how it can change. I think this slide would be helpful. Next, let's go to the next. Okay, so what did Rylan's Law? This slide talks about the historic or how North Carolina, I think to our previous panelist position and perspective, how North Carolina underfunds the child welfare system. When you look at, these are the states that are all North Carolina state supervised, county administered. And when you look at North Carolina in comparison, there's an underinvestment in the child welfare system. And so you see us there as the lowest of all states. Okay, let's go to the next slide. And I'm going to pivot and talk a little bit about what Rylan's Law actually did. So Rylan's Law, the Social Services and Child Welfare Accountability Act, looked at looked at all of social services, but it had a specific focus on child welfare. And what was some of the most valuable components of that were really the evaluation of social services by a third-party evaluator, and that was the Center for Supportive Families. They created a roadmap, they created a lot of information, and that was used by the Social Services Working Group. And the Social Services Working Group was community leaders, state leaders, advocates that came together and looked at what does social services need to be? How do we need to change to better serve children and families in North Carolina? So DHHS took that information and the recommendations from both of these, the Social Services Working Group and the third-party evaluation, and accepted some of the recommendations and started developing what we call a regional support model. So let's go to the next slide and I'll talk about regional support. So the regional support is gradually being implemented in North Carolina, and it started with really deploying existing positions and then adding new positions as they were funded to the General Assembly. Next slide, please. And so this really happened. This slide shows how this happened over time. And so you looked at in 2019, we started redeploying staff. In 2022, the state received 14 positions, and we were able to add positions to the regional support model. We didn't get all positions in the funded through the General Assembly in 2022, but that allowed us to have 3 specific positions for the state to have oversight of counties, and that would be a continuous quality improvement specialist, a permanency specialist, that's foster care, and then a safety, which is for your CPS realm. Additionally, the state leveraged other resources to add two additional positions. One was a regional abuse medical specialist through a contract with UNC to primarily provide consultation to counties for children 0 to 3, and then a system of care coordinator for each region, and that's through the Family First Prevention Services Act. But one of the real important factors in the regional support model was having regional directors. And so we only received funding for regional directors until 2023. We were able to add 7 regional directors. So these are directors. If you think about the social services system in North Carolina, it's state supervised, county administered, and there are 100 DSS directors. Well, the regional directors are the entity that coach and support the county directors. In North Carolina, from the General Assembly, received that funding late in 2023. So we had quickly hired and now have hired 6 of the 7 regional directors in the regional support. So let's go to the next slide. So the map, when you look at the map here, the map is on your right, and that map shows you the 7 regions in North Carolina and how they are distinct regions. The original plan for regional support, the top information shows you what the goal was in having regional offices, who would be in those offices. And the bottom really shows you currently what was not funded. And so the vision for this was really regional facilities, not, these people are primarily field-based, but they needed meeting spaces, convening space to bring counties together, because that regional oversight, it breaks 100 into 7. And then there are lots of needs to meet. So right now, our regional teams meet in their regions, but they are primarily home-based staff without the regional facilities. Next slide, please. Okay. So some of the recommendations from Rylan's Law, these were I'm going to go over where we are with these, but this was really the recommendation from Rylan's Law from the third-party evaluation. around what North Carolina needed to change in the child welfare system. And it had the core principles of cultural competency, trauma-informed care, family-centered, and really being safety focused. Because as you remember, Rylan's Law was really about safety. There was a lot in there about safety decisions after the tragic death of Rylan Ott. So the next slide goes over really, I want to quickly go over really where we are from Rylan's Law. Some of the actions taken. We developed a model for shared leadership and stakeholder engagement. We meet regularly 2 times a month with a unified leadership team, which includes state leaders and county DSS directors, to make decisions together about how to manage child welfare and how to manage the progressive changes that resulted from Rylan's Law. One of the recommendations was enhanced data tracking system. We now have plans for a rollout of a child welfare case management system that is state of the art that will roll out at the beginning of 2025. And it's called Path NC. Also, we implemented a practice model. One of the concerns of Rylan's Law was the practice was inconsistent and there was no continuity. I think the culture eats strategy for lunch. If you don't have a consistent way of practicing, that always happens. So North Carolina now has a practice model and it has revised all of its child welfare training. It is more prevention focused, focuses on those decision points and also how to engage families in preventing children, in keeping children safe. And that new training was statewide in July of 2024. We reinstituted a university training program. I'm going to talk a little bit about one of the challenges of workforce, but being able to recruit people to do child welfare. It is a significantly difficult job that requires trained people who know how to engage with families. When Ms. Sotolongo talked about the Indigent Defense Program, the multidisciplinary teams that have social workers paired with legal, that's a result of the work we did to add a finance team to North Carolina Division of Social Services, being able to leverage different revenue sources and add that team. That was possible because of some of the work we did to maximize federal revenues. Also, there were changes. There was a recommendation to streamline fatality reviews. And in addition, Rylan's Law had a lot of recommendations around coordination of community services. And so there was a coordinated action plan that we did to look at how did we leverage all of DHHS services to really provide better care for children and families in the child welfare system. And then leveraging a child and family services plan, which is our Medicaid plan that should come to be in 2025. And that plan really has the capacity to serve both that population of children that are open. When I talked about CPS in-home, that's your prevention. That's before entry into foster care. This plan, if children are Medicaid eligible, the children and families would be able to be a part of that plan in that prevention work, as well as if they entered foster care. And then we launched the partnership for the administrative office. We marked the partnership with the Administrative Office of Courts to launch the 0 to 3 program, Safe Babies Courts, which is a court program that puts services in very early and does a really good job increasing reunification rates for parents. All right, next slide. So I'm going to briefly cover some of the other strategies to improve outcomes. We've done there was a historic investment, I'm sure you are aware, of behavioral health funding, and we were able to do cross-divisional work, not just to focus on families that are that receive child welfare services, but services for all families, so that less families come to the attention of child welfare. Our Family First Prevention Services, our federally approved plan, includes home builders, parents as teachers, PPP, and multi-systemic therapy. And this, through the use of the Family First Prevention Services Act, will allow us to launch more programs that prevent children from entering foster care. We're very excited about a model that we're piloting in a couple of counties across the state, the Sobriety Treatment and Response Team START, that prevents entry in foster care. And Buncombe County has had this program in its instance for a number of years and has seen a decrease in children entering foster care. And what it really does is it pairs parent partners with families when substance abuse disorder is an issue and can lead to children entering foster care.
Senator, this is a 2-minute warning.
I'm going to go.
Thank you.
Then other programs for parent reunification. And then I talked about kinship care support. We were able through additional funding from the General Assembly to be able to fund at half of the board rate support for kinship care providers. All right, next slide, please. Okay, some of the key challenges facing children and families. Lack of statewide availability of prevention services. We need those community programs, and building those statewide takes time. You need to have that, and that requires not only time and resources, but it also requires state staff to lift contracts. You heard about the need, the workforce issues, and they impact our ability to be able to lift programs in a timely manner. Next, children remain in the system for too long. We have workforce challenges. I'm not going to go into a lot of details because I did submit slides about those. Insufficient court resources and variations in practices. So courts are local. There is not enough court time to get children to have the number of hearings that need to be held to get children out of foster care in a timely manner. And the longer children stay in the system, the more likely they are to experience more placements and increased trauma. Children experience too many placements. The turnover in our workforce really means that children don't have people who know the continuity of their care, and makes it more likely when children have, the more workers there are, there's a correlation in the more placements children have. We need adequate mental health resources, and we've talked about children in inappropriate settings. Let's go to the next slide, please. So counties are facing a workforce crisis. When you look at DSS positions, they're mostly funded through county and federal resources. There's different levels of funding in counties, and this goes back to consistencies. There's a wide variance in salaries across the state, and the primary reason that workers leave is to go to another county. And so you look at, these are difficult jobs. Often workers can make a salary working in other fields that are much easier, less evening hours. And when you work well with families, it means you're there when they need you, and typically those are evenings. Next slide, please.
Hi, Senator. I'm going to have to cut your time short right now. If you can please submit your full slides to us so that we can review, and I thank you for your time right now. And ask that we have to move on to our Q&A session. At this time, I would like to go straight into the Q&A. For our Q&A, I will use our roll call and invite committee members to participate. Each committee member will have the opportunity to ask one question, and if time allows, I will circle back and you can raise your hand for a follow-up question. Members will also have the opportunity to send staff any follow-up questions in writing after today's briefing, which will be compiled and shared with the panelists. I ask members to keep your questions brief to allow for a sufficient time to respond. Please focus on questions and not statements at this time. To the extent possible, please ask your question to one specific panelist. And I will begin. My question will be for Senator Cauley. I would like to ask regarding your information regarding the oversight and the regional directors. Are they on the same page as far as sharing information to the different counties? Because I hear about inconsistency. So what consistency, I guess, is my question, is in place now?
So one of the roles of the regional directors really is to make sure that there's, first of all, clarity around what is expected from county departments of social services. And they are responsible for all services. So they have the whole scope of DSS. They do a lot of good work making sure that county directors stay abreast of those changes and connect them with program resources that are state staff to make sure that they have the resources, and then connecting their child, when you think about child welfare, making sure that their child welfare staff are connected.
And I do apologize for the senator. God, I'm sorry about that. I'm going to go on to our next, let's see, where's my roll call list? Is Daniel Bowes present? Did he come online?
Not yet, Chair.
Okay, I'm sorry, I'm looking for my roll call. It's here. Excuse me just a moment. Okay, here we go. Our next person present, Marcus Gatson.
Yes, thank you very much to all of you. And this will be for Senator Grafstein. I appreciate you joining us and also sharing your personal experience raising children. I wanted to ask you if you could share what you see as a potential role for changes to courts under current legislation. So in other words, I know that you've mentioned some efforts in the legislature for changes. Both you and Director Cauley did that, but could you speak to changes you think that courts could undertake on their own without any changes in legislation that might improve the situation?
Right. I think that's tough. Going back to the point about the culture piece of it, right? So a lot of what we see from the disability rights perspective is simply a lack of an understanding or inquiry about how disability may be playing a role in that context, or what other factors may be going into it. I think the question around this idea of putting other resources in place for families before removal is considered or before some other actions are taken, to me that would be a role for courts. And I suppose that could be done legislatively, more more directive efforts at the courts. But to me, there's a gap where if we are not having courts inquiring as to what the alternatives are that are available before a child is removed, what the alternatives are that could be available in terms of providing resources to a family, I think those would be important factors. One of the difficulties that we have in the courts is that sometimes judges want to order things that are not available because the services aren't currently available in the community. So, for example, mental health services, other things that are where we have gaps in the systems. So I think we could empower judges either through education or legislatively to be more proactive in some of those inquiries. But I think a lot of that has to do with educating them about some of these issues that, for example, Sotolongo brought up around the other kinds of traumas that occur if we don't make those efforts before removal occurs. And I would also defer to the other panelists that are really having much more expertise, again, on the day-to-day.
Thank you, Senator.
Would the other panelists like to speak on this topic, on this question?
The only thing I would add to it is that there is a judicial juvenile certification program which allows judges who want to know more about this area and be a better judge on the bench can get that certification. And so it's been something that we've strongly encouraged, that it be that only judges who have gotten that certification preside over these cases, because they really do have the extra training and knowledge around the complexities that come before them.
And I think we support and appreciate the one judge, one family model, where there's one consistent judge who hears cases from the time that families begin a court process, as opposed to rotating judges.
Thank you all very much, and Marcus, for your question. Our next committee member, Stephen Green.
Okay, can you hear me okay? I'm using a microphone. I don't usually. Okay, good. So, okay, I'm not 100% sure who my question should best be directed to, so I'll just ask it. Based on the testimony today, based on what we've heard so far, I'm convinced that there's a real problem with culture. I'm also convinced that there's a real problem with resources. And I imagine that part of the problem with culture comes from being chronically under-resourced. So, yeah, that said, we live in a political reality. And in this political reality, I'm not optimistic we'll get the resources we need. What steps, what sorts of changes can be made that would hopefully most improve the culture that don't necessarily involve a substantial investment of new resources? And maybe that's hopeless, but I don't know. That's my question.
Any panelists, please?
I'd like to just sort of give a little commentary, and I actually think the other panelists are more positioned I think part of the issue is we chronically ask, what can we do in the absence of money, when money is the answer to a lot of things. And, so I appreciate it. And, absolutely want to see changes that wouldn't cost money, that could be implemented in a way that is politically feasible. But part of it is that there just has to be a demand that we do better, and we have to just not stop demanding that. And my fear is that we assume lack of money and then look for the alternative instead of spending that energy. But that's more of a political answer than a practical one.
This is Wendy Sotolongo. I love that answer. I do think there is one thing that we can do, and we are starting very, very small to do it, which is to actually ask the parents who have been impacted by the system what it is that they need, involve them in discussions around policy, involve them in discussions around legislation, involve in discussions around changing culture, to provide that community support. They know better than anybody the impact the system has, and I don't think that we can certainly involve them far more than we are doing now, without a significant cost.
So I would agree, and I think it's a multi-pronged strategy. I don't think it can happen. I think the funding has to happen. But if you think back over the slide where I showed the implementation of the regional support model, it didn't happen in 1 year. It happened over a period of 4. So you have to listen to what needs to change, the voices who are experiencing systems, and you have to have a plan and you have to be ready. And so even though we are just launching a regional support model, we know what we wanted it to look like from that third-party evaluation from Rylan's law. And so even if you don't have, you also have to change the work for the child welfare workforce. So even with we don't have enough workers, but we also knew before the pandemic, if we didn't offer a job that was really good social work, that was about preserving families and working with people where they are, the types of people that needed to go into people's homes in these critical times, they were not going to come to work. And so when I talked about that revision of pre-service training and a practice model, that's big. That puts social work back into child welfare. And so it's not there's still the workforce crisis, but we didn't say it's a workforce crisis, we can't solve it. It's a part of a strategic plan to change the culture because it's a practice model. It has expectations. The other thing I didn't go into in the presentation is a practice model has expectations for workers, and that's culture. So it says you're expected to communicate, to plan, to implement, and this is what it looks like in behavioral terms. So we developed that practice model with people with lived experience with county departments of social services to begin changing the culture, because any type of system change is not going to be quick and it's not going to happen overnight. It needs funding, it needs that culture change, it needs better training, and it needs workforce. And so I think you look at over time, but you have to keep listening because you have to know where you are. And I think some of this has been very impactful to listen to what the commission has heard and really get a feel, not that we don't do listening sessions, but this brings a broadened audience so we know where we are.
Thank you all very much. Next, Commissioner Jonathan Guzay.
Oh, thank you, everybody. With all due respect to Senator Grafstein, I think from our point of view, we've had a lot of individual stories, many of them very poignant, but we haven't had much data at all. And to that end, I have a question, or more accurately, a request for Director Cauley, and that is, you presented a flow chart at the beginning of your presentation. I wonder if it would be possible to get numbers and percentages for the various steps in that flow chart, because we heard about a few, but not very many, and I think that would be very helpful. Thank you.
Glad to provide that.
Thank you. Our next Commissioner, Jennifer Lechner.
Great. Thank you, Chair Wright. And thank you to all of our panelists for coming here before us today and for your very thoughtful and helpful remarks. I appreciate in particular Ms. Sotolongo's written remarks that she gave with all of the sites to the stats that she gave us in her testimony. This is kind of a two-parter and is probably directed both to Ms. Sotolongo and to Director Cauley. I heard you say, and hopefully I'm not misquoting you here, that there should be a requirement to the court to investigate trauma and how to incorporate that into the consideration of removal from a child from the home. And then Director Cauley, I heard you say again, if my notes are accurate, that there's insufficient court resources and variation in practice. And so I'm wondering what systems are in place to have that conversation between and among the various agencies and the court system, and bonus points if you want to incorporate the ACEs task force that was established by Chief Justice Newby, and whether any of those recommendations are making it into policy considerations.
I think it is a two-part answer. By the time a social worker comes to court asking a judge, through their attorney, asking to remove a child from the home, that culture's got to change. That they need to be. That's got to be part of their policy and their culture, in knowing more about the trauma of removal, so that it really is important to try and avoid it. So really the court part is kind of a stop, like that final effort to try and prevent it. And a lot of courts now there's not even a hearing around that first removal. It is usually done ex parte, where DSS attorney shows up and asks for removal without anybody being heard. So we need to have the judges understand the trauma, so that they are the final kind of guard toward asking and really questioning the social worker around what efforts have been taken to prevent this removal, prevent this trauma.
And the 0 to 3 Safe Babies program that I talked about, that came out of the ACEs task force. So there's really good work that's coming out of that. But courts are local. So it's a local entity that has to have capacity. There are many times where you need to go back to court, but the court dockets are there's so little time there that you can't, if you're a social worker, you can't get back in. And you see that in cases where children need to go home sooner, but you can't get it back into court to be able to send children home sooner. And it's a resource issue. And I think that the attorney issue compounds it too, because there's not enough parent attorneys, there's not enough guardian ad litem attorneys.
Thank you. Our next committee member, Donna Oldham.
Thank you, Madam Chair. Thank you, panelists. My question is for Ms. Sotolongo. You mentioned a Georgia program that is so successful. What does North Carolina need to do to get aligned with that program that you mentioned?
I think that's a great question. I mentioned it because I do think it can serve as a role model, but what she did was very much community-based. This was a woman with great vision who pulled together people who cared about families. So, I know that government needs to support these kind of organizations. I think even, everyone will tell you that if the community can help families, then that is less burden on the government and less intrusion on families by the government. So I would love to see community organizations in these communities to reach out to each other and say, what can we do to come together and provide this resource? There are some, and I'm not going to be the expert on this, but I know that there in another state, they actually have, the communities have an app where a parent can literally go and look on the app for what they need. I need food today. I need furniture today. I need housing today, and be able to get connected with resources. So there's ways that technology can help us, and there's just communities coming together.
Thank you very much.
Thank you. Our next committee member, Catherine Reed.
Hi, thanks also to the panelists for the information shared today. The first question I had was a clarification just for Director Cauley around the resource issue and how North Carolina is falling behind its peers. Is this been a chronic problem over decades, or is this something that's got worse since Rylan's law? Is the funding Has it been chronically behind, or is that something that's more recent?
So that data is new. I think that's data we've just recently, we've looked at it within the past couple of years. So I'm going to speak from what I believe. I believe it's chronic. I think when you look at what others, but it's also based on a period of time, like what did it, so other states may have changed too. But if you look at some of the lack of transformation in child welfare, I would, there has not been a lot of transformation in child welfare since we did the multiple response system 20 years ago. So that it kind of falls in that same pattern. It's a system that's been underfunded until Rylan's Law, not a system that we really took care of and really looked at how do we need to change this system to provide better outcomes.
Thank you.
Thank you very much. Our next committee member, Mercedes Vespuccia.
Thank you for all the speakers. It's been really informative, and I think I just have kind of a clarification question to ask, and I think it might be best directed to Ms. Sotolongo, but others please feel free to pitch in. And just, I guess my understanding is, I think I've heard somebody mention that an attorney is not actually appointed to the parent until actual abuse and neglect charges are pressed. And then, this kind of, our briefing is grounded in Rylan's Law, and I understand Rylan's Law now requires about 3 visits before reunification can occur by the social worker. And so I guess I'm wondering, with the parent not having an advocate prior to the charges being brought, and having this like 1 hour visit a week. I'm not exactly sure where my question is, but you'd mentioned, Ms. Sotolongo, that there's these interdisciplinary teams, and if you could kind of maybe elaborate on that, and if there's been any discussion on getting parent advocates online before the charges are actually pressed.
Yeah, thank you. I think there you touched on a multiple things in that, but no, all extremely important. Pre-petition has been something that has been tried across the country, and it's with great success. There have been programs that did it, and no children came into foster care, even though they were at imminent risk of coming into foster care. And that's because a lot of the issues that parents face, neglect, is pretty much poverty driven. And so we have in North Carolina, there is now one program that is starting a pre-petition or diversion program. And it's a legal aid organization called Pisgah Legal Services, who got a grant from Duke Endowment in order to try this in North Carolina. Again, in other states, when a parent is at imminent risk of losing their child, the attorney comes in and tries to address whatever concerns, the safety concerns that the agency has, and is usually very successful in meeting those concerns and keeping the child in the home. So we've just got to shut the door. We've got to close the door to kids coming into the system and provide them the services they need before it gets to that point. So that's a great start in North Carolina, and it is certainly our hope that, and we've talked with state DSS, that at some point we, do endowments help us start programs, but we need funding to sustain them. And so it is our hope that we can access some federal 4E money around doing more pre-petition work. So that is a big goal of ours. Once a child is in the system, it is, all those same concerns are there. Like, we really still need to address whatever the concerns are, that the needs of the family and the concerns of the agency, to address them as quickly as possible and get the child home. The visits about Rylan's Law have been, there are times where it is difficult to get the Rylan's Law visits in with court because of the shortage in court hearings. And so that has created some issues around delays in reunification because of not being able to get the Rylan's Law visits done in a timely manner. So.
And I guess one follow-up question is, the guardian ad litem for the child is also not appointed until charges are brought. Is that correct? Or
that is correct.
Guardian ad litem,
we have a system in North Carolina where the child has a volunteer appointed to them when a petition is filed, and then they're also an attorney advocate, and they work together as a team. to represent the best interests, not the express interests, but the best interests of the child. So again, it's many things, I think, as Director Cauley pointed out, is some of the things that children need around behavioral issues and mental health issues, and parents are not able to access that. And again, if there was some advocacy before we had to go to court and before a petition got filed, that would probably reduce the number of children coming out, being taken out of their homes.
Thank you.
Okay, thank you. We have 15 minutes left, so we're going to start a second round of questions for anyone with a follow-up. And I will begin with, and I don't recall, so I'm not going to call a name, but there was the 2025 data system that is to come out. My question would be, is there training for adequate use? And when is it expected to roll out?
So this is North Carolina. We didn't talk about this, but one of the things that North Carolina lacks is a comprehensive child welfare information system. And so you have 25 counties that are in intake and assessment of an older system, and 11 that are in a end-to-end system, but no one system for 100 counties. And that's a big issue. And so it makes even getting the data, and I really agree. It's not just the data, but what do you do with it? What does it mean? It makes even getting the data difficult, because for 75 counties, they're not even in a state system. And so it's NC Path, and it was done with a vendor, and a vendor is working with us to build the system, and it incorporates that practice model I talked about. And so it will roll out beginning in the beginning of 2025. And one of the things that will happen is there will be training on practice and what you're supposed to do with families and services, and then the automation of how's it automated. And so it starts with intake and assessments, and then rolls across the state, and then we'll go into that in-home services and permanency plan and foster care and adoptions. But it will be one of the biggest changes that we have in North Carolina, because it will give transparent. It will be able, when you think about state oversight, it's difficult to even see what's happening in 100 counties when they're in a lot of different systems. And let me add one thing too. I think I talked about the workforce, our concerns about a workforce. It has so many really good features that will be efficiencies for workers and supervisors to be able to better work their cases and minimize the time they spend in a system.
Thank you. Marcus Gatson, did you have a follow-up?
I have no follow-ups at this time, Chair Wright.
Thank you. Stephen Green?
Yeah, I do, actually. Would it be possible to bring back up those PowerPoint slides that Ms. Cauley was showing us earlier?
Yes, just a moment.
There's a question, Stephen, directly?
Yeah, I have a question about, like, when I was looking at these slides, that it's like, okay, if I have a second question, I'm gonna ask. If it was one of the first couple of slides about how the system works. Okay. Excellent. Okay, right. Yeah, right here. No, back up even. This flow chart here, the previous slide. Right. So I'm looking at what is this? Family receives in-home services versus child enters foster care. Now, I don't know, just thinking about it, it seems to me a lot of the stories, a lot of the testimony we heard last week made it sound like, I don't know, like there's just mistakes going on there. And that I don't know how much that's a matter of resources. It certainly seemed like there was a problem of culture there. That I just feel like that might be a breakdown. Like too many are going from that step, which is a huge step that doesn't need to happen. And I certainly know we heard stories of once the child has entered foster care, that, in theory, kinship care is the preferred option. But so many kids, it sounded like, we were just hearing story after story, had grandmothers, aunts, uncles, whatever, people who wanted to take care of them. In one case, a father who wanted to take care of them. And they went to foster homes. And you know, it's just looking at that chart was like, but we've heard stories, real testimony of just breakdowns in this system. And I don't know. I guess that's more a comment than a question. But the question is, what do we do? All right. So that's my question.
So these are all decision points, and the decision points are really important. And so if you look at when you do a CPS assessment, like if you determine that a child, to keep a case open, you determine that a child was abused, neglected, or dependent. To do that well and keep children from entering foster care, you have to be able to explain to the parent what is not safe here today, right now. That's a skill. And then you have to be able to explain, let's talk about what you can do to change that. Like what can change? What are the things that can be done to mitigate it? There are some things, there's a lot of things you can do to safety plan for children. And there's some things you can't. And so that real point right there is whether or not a family is going to go to in-home services where the child's going to stay in the home, but you're going to put a plan in place. And if there's no plan that you can come up with, then foster care is an option. I mean, that's where you go. But there are a lot of families that work well to figure out how to protect children, even when there are things that we call it conditionally safe. A practice model. When I talked about a practice model and I talked about a more skilled workforce, you have to think through this in the moment with families. Okay, and I've got to be able to talk about, okay, this, and I'm not going to give you examples, but I got to be able to bring in the real life examples of what's not safe in your home today, and then help work with you to change that in order to prevent removal. And that work is difficult, and it requires a very skilled workforce. And so what can you do? Continue to try to attract the right people who will get in there and do that good work with families that listen to, because if you don't get to the real problem, you can't change it. So there's that. And then courts come in too, because when you go to court, you have to be able, and you're going to take custody of someone's child. You have to tell a judge the reasonable efforts you made to prevent that. And so judges that have like pushed back and say, okay, you know, like what are the reasonable efforts? Really reviewing that's important too. Does that help?
It sounds like you're saying too many times we have an inadequately skilled workforce, and that was kind of a sense I got last week or last hearing too. I think the workforce is new. The workforce turns over. There are not enough people working. Yes. So when you have those dynamics, you know, do you have the time you need to spend with every case? I think that's why funding the workforce, you know, state aid to counties would provide counties with more funding to be able to have higher salaries, add more positions, whatever the issues are that prevent them from having enough staff. So it might not always be the skill. The skill is important, but it might be the adequate time to do that work.
If I may add into that, I think the question also gets back to this, you know, the issue of trying to get sort of a root cause analysis of why, right? That the stories matter, right? They're not the plural of anecdote is not data, right? It's not the same thing, but they should be a signpost that something went wrong here. And I absolutely, you know, would expect that some of it has to do with staffing and funding and that sort of thing. But I think we have to, you know, it sounds like you all have heard a lot of stories in some of the sessions I've listened to. There have been a lot of compelling stories. I think it's important that we continue to credit those stories and take them seriously and look for in individual cases what went wrong here. And it might be inadequate staffing, it might be inadequate experience, but we need to drill down before we make assumptions about that. I think it would be a mistake to say, well, we need to study this for 10 years and not raise anybody's pay until then. I'm not suggesting that. But I do think we have to be really careful not to assume that things are working at this level because the data looks one way when we're hearing story after story. That sort of makes it clear that something's going awry. So that I just wanted to reiterate that point, because I think that was the main thing I was trying to convey here is that the analysis that needs to be done, the data collected needs to reflect, you know, people's real life experiences.
Thank you, Jonathan Guzay. And we have questions. Unfortunately, we have to end at 12:30. So if there's anyone with a dying question, if you can raise your hand. I don't know that I will get to everyone.
I'm going to pass. Jonathan, if somebody else has a question, they can go ahead.
Does anyone have a dying question? raise your hand, please, and we can get to you. Okay, Jonathan, please go ahead.
No, I'm passing. If anybody else wants to ask a question, let them go ahead, please.
Well, no one else raised their hand.
Well, then I'll make a comment, and that is that, Stephen, addressing, I don't think we could, and I know we can't take every story we heard at face value. Senator Grafstein said we have to drill down, and we are going to drill down. I've done some drilling down, and believe me, not all those stories are as clear cut as they sounded. That's the first thing. And second thing is, just to your particular point, we found out that only 4 to 5% of the people in that flow chart end up in foster care. That's not the impression we would have gotten from just listening to individual stories. And furthermore, we found out that even right now, about 25% of them end up in family placement. We wouldn't have gotten that impression from a few anecdotes either. So it's important to get actual numbers, and I'm hoping we will get them. Thank you.
Thank you. All right.
And actually, sure,
Yes.
sure, right. I do have one question just to clarify. And based on that spreadsheet, there was a star, the flow chart. When for the first time the court needs to act, is that when an abuse and neglect substantiation is being made when a child is being referred into foster care, or does that substantiation happen after the child enters foster care?
I'll start and let Ms. Sotolongo add the legal perspective. No, that's not when it starts. So that decision around whether maltreatment occurred happens after a CPS assessment. So when the worker goes to the home, talks to the family, puts the information together, that may or may not be any type of charge. Like the charge would be a criminal charge, but they would make, typically called a finding of maltreatment would be made then. And at that point, there's a decision that's made, like the decision of can the child remain in the home with a plan is made there. And then the court comes into play only if, and there are rare times the county may approach a court if they need court oversight in-home cases where children remain in the home. But for the most part, the court is only going to be engaged if there's a need to place the child into custody of the Department of Social Services.
The only thing I wanted to add on top of that was I absolutely agree that data is something that we all need more of, and it will help all of us do our jobs. The other thing I do want to mention is that the regional oversight has definitely brought an improvement to North Carolina, and it really needs to be fully funded. I have had consults with attorneys who their client's case has been, the local agency got a state person to come in, this regional supervision, and it really directly changed the trajectory of the case because the state came in and pointed out some problems that they'd done, some mistakes that had been made, and tried to get it rectified. So I do feel like the purpose of Rylan's Law and trying to get regional oversight and to increase that really does need to be fully funded because it has helped in individual cases.
All right. Thank you again to all of our panelists for presenting at today's web briefing and for the committee's engagement. We will now transition to public comment. If we run out of time and members of the public are interested in sharing comments with the committee, please remember we will continue to accept written testimony until September 23rd, 2024 at lschiller@usccr.gov. As a reminder to committee members, we have a meeting following the break. And the ground rules for committee members, before we begin public comment, I would like to remind committee members that this is an opportunity for us to hear from the public. This is not a space to engage in discussion or substantive questions. If a committee member needs to make a clarifying question of a public commenter, please raise your hand and I, in my discretion, will determine if the question is appropriate. Please note that the USCCR is not an enforcement agency, and the committee's primary task is to send recommendations to the Commission on Civil Rights topics. The public comment section is intended for any members of the public to share their thoughts or experiences related to the topic at hand. This is not a Q&A session. We are required to obtain the legal names of anyone providing public comment. As required by the Federal Advisory Committee and its regulations, the chair must ensure that detailed minutes of meetings are kept. And those minutes must include a list of persons who were present at the meeting, including members of the public who present. To provide a comment, please raise your hand in Zoom. You will have 3 minutes and will be given a heads up when the time is almost up. Please do not defame or degrade any person or entity. If needed, we may intervene to redirect the comment to the topic at hand or to obtain a respectful environment. After a warning, the chair and the USCCR staff have the right to mute anyone or adjourn the meeting if needed. Written comments can be submitted to lschiller@usccr.gov by September 23rd, 2024. Also, please note if you have previously shared comments, we may prioritize those who have not yet had an opportunity to speak, and we will accommodate as many individuals as time allows. I'll now call on staff to assist with public comment. Staff will call on and inform members of the public when to unmute.
Thank you, Chair. At this time, I'd like to ask Ethiopia Lane to speak, and you can begin your remarks when the timer becomes visible.
I thank you for allowing me to speak. I am Ethiopia Lane, a lived experience family advocate. It seems North Carolina is also having the same crisis with workers and judges failing to practice and implement the model of the 2018 Family First Prevention Services Act, which New York also ignores. CAPTA is the model that has failed for 47 years. CAPTA should be looked at within this study. Director Cauley mentioned a new tracking system. Since 2022, articles have been published regarding algorithms, current concerns of bias within the child welfare tracking and monitoring. I asked this committee to review recommendations from the report of the New York Advisory Committee to the U.S. Commission on Civil Rights issued May 2024 on page 104, 114, and 115, which is to continue to refine the mandated reporting system, its processes, and its implementation via comprehensive data collection, analysis, and refined algorithms, pattern recognition. I also ask that you please hire an AI consultant that is an expert in bias algorithms. I also ask the committee to also investigate the number of foster children that are missing children. There is a very significant number. Thank you for your time. Thank you so much.
Thank you for your comments. The next speaker will be Jeter Anderson.
Hi. Yes, I'd like to speak today about what had happened with my family, my sister, and we had sought help for my sister. She was mentally ill. And by the way, I want to shout out to Stephen Green about that flow chart. Y'all stay on that flow chart about Ms. Lisa Cauley. My sister was screened wrong, and because she was screened wrong, it caused a disaster. A child taken, she died. She got bullied, and because she got sent down the wrong part of that flow chart. And Lisa does keep saying the same thing over and over when asked about that flow chart. She needs to explain to the public and everybody, what happens if you don't do that. I mean, we got Jessica Bridges, a DSS worker up here, who keeps coming back after she just quits and did something crazy. And we get no answers. Transparency, there's none. We ask why our child is taken. We get no reason why our child is taken. We ask why our middle daughter was denied help. She was vulnerable. She was a federal helpless child. Was it because it was a Black child and he was white? We don't have no reasons. We don't have no answers. There was no they just come and snatched our child. I got the video, and it caused death. It caused death on Erica Anderson, and we're still traumatized and hurt. And you can view us at the county board, and we're asking the head of DSS, Mike Downs, why the heck did he take our child? Why the heck would he do this to somebody? And I appreciate everybody on here for listening, and maybe my dad will get to pop up. He's a veteran, and this happened to him, and he has to relive it and go through this. We don't get no answers from nobody. And my sister didn't deserve it. She was a good girl. All she needed was a little help. She was vulnerable. We went up there. She needed medicines. She had a diagnosis, but everything was good in our family. It became a report. Just help became a report. We didn't receive help, and we got trashed, and we got hurt, and they're covering it up here, and it's so ridiculous. It's so ridiculous. You can view it the county board every month. We're up there, we're speaking, and I'm gonna always speak about it because Erica didn't have a voice, because J.H. White is a private attorney here in Cabarrus County, and he's also a prosecutor, and judge is in cahoots. And you're not gonna get your child back. Thank y'all. Thank y'all for letting me speak.
So I would like to invite Lisa Cauley, if you would like to respond to this commenter.
Chart, so.
Thank you. And I think the flow chart is there to understand the process. That doesn't mean that this is difficult work, and there are difficult decisions that impact people's lives. So thank you for that perspective. If there's any, I'll provide the clarification around the numbers as I was asked previously.
Thank you very much. And I will turn it back over to the staff.
Thanks, Chair. The next speaker will be Jerry Anderson.
Yes. I'm Jerry Anderson, and the DSS has become a reporting agency, and when you go up there, it says for resources, and I went up there for resources, and this lady who was anyway, she was like in charge. She talked with me, and I tried to tell her about my daughter, and she made a report out of it, went after her daughter, my grandchild, and they did a investigation for 5 months. All I was trying to do was get help for my mental daughter. My mental daughter was 25, and she had a 7-year-old child. And I've gotten help from my daughters many times, and never has my grandchild, nobody reported nothing. I just went to get help.
Really?
And
You okay?
they went through 5 months and said, if the child stays at my house, everything's fine, I said, what about my daughter? What about my daughter? They gave me a legal paperwork, and then I went up there to clarify it, and they said I was reported again, and they reported my daughter again. So after a 5-month investigation, she started another investigation, and lo and behold, they beat my daughter so bad, my mental daughter so bad, she had to go to the mental hospital. And while she was in the mental hospital, they called me 2 times in the week to my house, the DSS workers, asking me where my daughter was. And I said, mental hospital, y'all put her there, beating her up. And they called me on a Tuesday and a Thursday, and then on a Saturday, not on the weekdays. My granddaughter been to school all them days. Come on a Saturday night and took my daughter. Asked them why. They said, you didn't get a phone call? I said, no. And I never found out why they come and took my daughter, but I never seen her again after that night. Never seen her again, not no reunification. They went through court system, took my mental daughter through the court system, the whole thing up here in Cabarrus County. And Mike Downs did an investigation, and he won't tell us. I go to the board meeting. I said, Mike Downs, why y'all take my child? Mike Downs, I've asked DSS. Nobody will tell me. So the scandal is 4916. 4916. Erica Sue Anderson scandal in Cabarrus County. Thank you. And I'm sorry, I get emotional.
Thank you for your comments. The next speaker will be Yolanda Rushing.
Thank you. Let's be honest, there are too many children in our foster care system, and this is not solely based on protecting the child. We have heard experiences of children being removed under questionable circumstances. Not enough homes, you say? No, there is just too many children being removed just for the funding, yet the funding is not spent on reunifying the family. Rylan's law is not creating consistency, but rather adds to the entangled affair of families navigating a complex, inundated system, fighting for their children alone. There is no clear complaint process, which further wraps scrutiny of how this agency, quote unquote, governs. Monitoring is watching. Governing enforces accountability. I have no faith in the regional structure model. So we will continue to have 100 counties operating 100 different ways. And to add to this, the state then says, let's put an additional layer of splitting this 100 counties into 7 regions to do 7 different things. Again, decentralization does not lead to consistency. Not to mention, the agency recycles directors and workers, even those that were found to do wrong in one county, but then goes to another county. Tell the public the truth. When matters are discussed and when we have to navigate this system, you send us to file complaints to the constituent's office. We don't get information there because it's hidden under the disguise of confidentiality. Yes, the case is confidential, but why are we hiding what the agency did wrong when tax dollars are being spent? We should be made aware of what the agency is not doing right. You say one judge, one family, I've seen 4. There is no adequate training. You are allowing unlicensed workers to determine what is in the best interest of children. Why is this agency running from accountability? Changes can only be made by lawmakers, and nobody's saying anything. When an agency starts to remove children for no reason, you have more than a problem. You have an issue with an underlying root cause that you all are continuing to ignore. Thank you.
Thank you for your comments. The next speaker is James Campbell. James, you can begin.
Good afternoon, and I want to thank you guys for speaking today. But let's be honest. Let's start putting truth to power. We looked at a nice, pretty flow chart, but one thing that flow chart was missing, what happens when a social worker goes rogue? I can really tell you what happens when a social worker goes rogue, because there's no checks and balances in line when a DSS worker operates on a vendetta. As my wife so eloquently spoke, there is not just a county just in Cabarrus County, but there's accountability issues statewide. And yes, there's different avenues in regards to what we can do to help children, but let's be honest, DSS is not the way to go. I mean, There was nothing on the flow chart to say what happens when a DSS worker does something wrong. When are they going to be able to be taking accountability? My wife and I have been impacted for, as of today's date, for 365 days. And you want to know how the state of our children are? The state of our children are not well. We have two that's in a foster home. We have another one who was shipped across state lines. And we have one who is living with her accuser until this day. There's judges, attorneys, and sit in county leadership who all do not want to take accountability when they all can implement policies and procedures to rectify this issue. And my question to you is, you are the director statewide at NCDHS. It's time for you to actually take accountability as well to what's going on statewide. We have 100 counties operating 100 different ways, but then broken down to 7 regions. I'm not the smartest person in the room, but how much sense does that make? When you're removing children from well-educated, loving families, there's a problem with your system. So it doesn't need reform. I think you know what it definitely needs. And reformation is not it. You're hearing people speak about all issues that have been affected their family. But the one thing that this system is committing, trauma. Trauma to my wife and I, trauma to every family in this state who has been impacted negatively by your system that was built to supposedly help, but it's actually caused more harm than help. Thank you.
Thank you for your comments. Chair, I'll pass the floor to you.
Yes, thank you. My audio thing was broken. Again, I would like to call on Ms. Cauley because your reference was made. So I would like to allow you the opportunity to respond if you would like.
Thank you so much. I think in a state supervised county administered system, the oversight is a partnership between state and counties. If there is a case of concern that needs to be looked into, please address that with our constituent concerns, and we can reach out to the county and see if there's just any information we can learn. The regional support model does rely on that partnership between the state and counties.
Thank you very much. I will turn it back over to staff.
Thanks, Chair. The next speaker is Yvonne Pollard.
Good afternoon. Are you able to hear me?
Yes, go ahead.
Yes, I've been coming to the meetings, and I'd like to thank everyone for their information and their input, oversight. But my problem is in New Hanover County, which is Wilmington, North Carolina, and that chart gave a lot of information. Now I can see where the mistakes that they do not want to admit that they made were made. My granddaughter, her name is Tyeva, she was taken at barely 3 months, and she was taken from my arms from something that they claimed that my daughter did not do. There was never abuse. There was never neglect. There was never any intentional harm or any harm, period. They went on what they assumed by looking at our family. They had changes in social workers in that short period because of the high turnover. The social worker that took our offspring was not experienced. She's younger than my daughter and probably doesn't even have any children. She did not know how to create a plan. And the plan that was in place by the social worker prior to her was being worked. But she came in and she didn't see what she thought it should look like. My granddaughter was safe with me. What they also are not admitting is that they gave a prior order. I have custody, full custody, and have had custody of her sibling. That was in 2019. She's 5 years old now. They allow visitation for 4 years. Yes, those 1 hours, but yes, those 1 hours add up over 4 years. Do they believe that we disappeared? Does she think that we are gone now? We haven't seen her in over a year, dead or alive. We want to know where our offspring is at. Do they get to violate her rights? Because my daughter didn't have a proper representation before these charges were filed. Someone can go in and make charges, and then we don't have adequate representation. They did not follow the Families First Act. I asked them about it. They said they didn't have to, and the other social workers were not even aware of what that was. So there's been mistakes, and Mr. Green was correct. Where in that chart do we fit? And Mr. Gouze, yes, some of these children do need to be taken, but in the Pollard case, this was a mistake that they don't want to admit. Please review it. Please have Taeva brought home. Thank you.
Thank you for your comment. That was the last hand raised, and I want to acknowledge where we are a bit ahead of schedule. We can accommodate potentially 2 more speakers if anyone else would like to raise their hand, but we do have limited capacity, so not everyone, we may not get to everyone. At this time, I see the next speaker is a call-in user. We will give you the opportunity to speak, but we will need to give you a 1-minute verbal warning since you won't be able to see the timer. And Liliana, if you can please set up the timer anyway for others' reference, and we'll base the timing off that. But you are now able to go ahead and start your remarks.
My name is Amy Betts. I am the biological mother of 3 children, and I've been an advocate in North Carolina and other places for biological families for over a decade with my nonprofit, Adelies. Children are being trafficked through this system, and it does not function humanely. It never has. Our nonprofit, Adelies, has data. Like many biological families across North Carolina and the U.S., my children and I have been unlawfully separated by this industry. We were separated their entire childhoods because of the crimes occurring against humanity at the hands of this for-profit industry. And it includes the agencies and other organizations appointed by judges in these courts. Separating a child from their biological family creates adverse child experiences and insurmountable, irreparable trauma. Yet it happens daily at the hands of this unlawful, inhumane industry. Note, agencies can only spend their budget on those specifically stated. Therefore, the processes that are being used by the court industry, which includes the child welfare agencies, are unlawful and must be revoked. Everyone should be asking these questions. What happened to the separation of powers? Why does this state continue to fund these crimes against humanity when they should be cutting funds? There is not a way to track data or the children, and there never has been. Why is no one listening to biological families when they are asked what is in their best interest? A solution? Stop separating children from their biological families. Where children have been separated, they must be returned. This industry must prevent the removal of children from their biological family and ensure all efforts are focused on reunification as mandatory. To do this, there must also be enforceable standards to ensure things such as outside adoptions do not occur. There must be enforceable ethical standards to ensure these court officers, which include judges and attorneys, don't continue to force services and violate the rights of families to prolong litigation and reunification. Biological families do have the right to resist coercive state intervention in their family. They also have a right to make decisions about their own children. Theft of inalienable rights under color of law, as well as legal abuses at the hands of the system, must be stopped. Biological family are blood related and nothing trumps that. These families are not bound without their consent. To ensure the rule of law, this industry must step up their requirements to preserve families and stop separating them. Thank you for your time.
Thank you for your comments. The last speaker for today will be Richard Wexler.
Hello, my name is Richard Wexler. I'm Executive Director of the National Coalition for Child Protection Reform. We've heard a lot of calls for data today, and quite rightly so. I will provide sources for what I'm about to suggest in my written statement, but there are a few key data points I'd like to highlight. Of all the children placed in North Carolina foster care in 2022, 83% were placed there even though there was not even an allegation of either physical abuse or sexual abuse. In 60% of the cases, there was not so much as an allegation of drug abuse in any form. Investigations alone, even without placement, are enormously traumatic for children. 1/3 of American children will endure that during their childhoods, and more than half of all Black children will endure that. So what is it that's overloading caseworkers? False reports, poverty cases, needless foster care. Get those cases out of the system, and workers will have that time that speakers spoke of to get to the children in real danger. And finally, I wish to respectfully disagree with the use of the word only in certain child welfare situations. For example, nationwide, 99.98% of the children who become known to Child Protective Services agencies are not victims of child abuse fatalities. But no one would say only 0.02% die, because the only acceptable goal for child abuse fatalities is 0. Similarly, 4% of children investigated wind up in foster care. I would respectfully suggest that this figure also not be preceded by only, because the only acceptable goal for needless foster care is 0. And by the way, the percentage of children placed in foster care will look lower simply if the number investigated is ridiculously high. And by the way, that 4% represents about 5,142 children. Some of them really needed to be placed. Many did not. Thank you very much.
Thank you. That concludes the public comment for today.
Thank you very much. I would like to thank all of the committee members and members of the public who participated today. We will continue to accept written testimony for this briefing until September 23rd, 2024. Please email written testimony and any questions, any data. Anyone on the line would like to share with us to today's briefing to L. Schiller at usccr.gov. Our next panel will focus on impacted individuals. It will take place on Friday, August 23rd at 1:00 p.m. Eastern Standard Time via Zoom. We hope you are able to join. Thank you all again. Members of the public are invited to stay on for our business portion of our meeting. We will now break for 5 minutes and resume with our business meeting at that time. Thank you. We will resume back at 1:02. Thank you.
Are you ready, Chair? Okay. I think you're muted at the moment.
Thank you. Are our members back? I can't see everyone. Or shall I just continue?
It looks like most members are back on the call.
Okay, thank you very much. I will continue with our business meeting at this time. Our announcements, pretty much Anna has sent us an email after the second briefing with a few announcements, so I want to remind you of them. We now have a public folder that houses all project-related materials such as minutes, presentation slides, recordings, transcripts, written testimony, etc. All documents that are discussed during business meetings will also be included in the public folder. This will help the committee stay organized when debriefing testimony and drafting the report. This folder is linked to our project page as well. You will notice that we use monday.com to house these documents, but to avoid duplicating efforts, staff will only house documents that are not yet ready for public release on monday.com in a designated board, which staff will clarify. Victoria and Anna have provided due dates for members to submit questions to panelists from the first and second briefings. Victoria initially asked members to submit questions directed to panel 1 speakers on July 30th, and Anna asked members to submit questions directed to panel 2 speakers by August 8th, tomorrow. At this time on your screen, let's see, staff provided a few questions. Do we have questions? Okay, great. To help us reflect on the oral testimony and written testimony we received, I will prioritize question 4 as we won't have time today to cover all of the questions. As you think about your responses, I'd also like for us to discuss which testimony is missing and what is the best way to obtain that information. And as a reminder, when we are planning these briefings, staff reach out to stakeholders to provide written testimony, and several others plan to submit comment by the September 23rd due date. Staff has also polled several other proposed speakers noted in our panelist nomination board on monday.com, and there were stakeholders recommended by members of the public. Looking at our timeline to complete this project, our term expires on May 13th, 2025. So we will need to wrap up our report ideally by late February or March to allow time for a legal sufficiency review. If we consider holding another briefing, please also know that it will take some time for staff to conduct outreach and schedule a meeting to confirm speakers. At the minimum, staff can accommodate 2 speakers. As an alternative, we can vote to send a request for written testimony from specific people and set a deadline. I'll now ask members to raise their hands so we can go from there. As far as, are there any specific key perspectives that you deem missing from the report? Let's see who we have up. All right, Jonathan Guzet.
You're muted, John.
I want to apologize to the committee as a whole and especially to the chair because I interjected some commentary during the question period and I shouldn't have done that. I'm very sorry.
Thank you. Apology accepted. Yes, Stephen.
So I'm not sure if we don't already have this scheduled because it's hard to keep track of everything, but I would be really interested to hear the perspective of one of the judges because it seems like they have a lot of power and they play a very important role in these situations. Because, one of my concerns is, there's been, to me, fairly compelling allegations of a lack of accountability. And I would think that the judges in family courts would be kind of like the first level of accountability. And so that's a perspective I think would be really valuable.
Thank you. We have Marcus Gatson.
That was actually an accident. I just wanted to indicate I agree with Stephen, and I wanted to do a thumbs up, but didn't see how to do that.
Thank you. Let's see if I can see any other hands up.
Oh, I'll raise my hand. Sorry, I didn't realize I was not unmuted. I think one thing that kind of, especially during this hearing, that stood out was that everybody was commenting about kind of the lack of like chronic underfunding. And I think that's something that is like a major theme. I think probably it directly impacted individuals are more along the line of don't fund at all, but I don't know that that's necessarily a very realistic solution, unfortunately, or fortunately, however you may see it. That lack of funding and is really preventing people from getting the training, getting the court resources that is needed. And then also, I think a theme that's popped up is this interdisciplinary defense teams. And so that is something that I was glad to hear that we've got a pilot project that's happening in North Carolina, and emphasizing that as something that it seems to me, if you were to get a robust defense team, advocate team, even for the parent and the child in advance of everything, that it would lead to less unnecessary removals. And then it would also help with kind of making sure that more resources, more court time. I mean, to me, it boggles my mind that they're like, there's not enough court time. We know the kid needs to be at home, but we need to get it on the docket. Like what? Like that is, and I'd be curious to hear what a judge has to say about that. But to me, it's I know enough because I've actually practiced law that it's not like in the TV, but I also know that you can call a judge up and be like, can we get this to happen? And it can happen. And so it's a little bit shocking to me that is a reality.
So you're agreeing that the judicial presence, we need that.
I think it would be interesting. I wonder if anybody would be willing to come to speak to us, but I think that it would help for sure. Maybe getting written comments of some sort.
Does anyone have any contacts or any
No, but she
avenue?
mentioned she did mention that there's these judicial juvenile certification judges, so probably one of those would be best. And Jennifer.
Yeah, I would recommend Judge Ashley Parker in Wake County. She's the abuse, neglect, and dependency judge here, and is not afraid to speak publicly about the system that she kind of oversees in Wake County. She also is a vice chair of my commission, the Equal Access to Justice Commission.
Would you put her name and county in the chat so that we can appropriately follow up, Jennifer? John, did you have
Chair, sorry,
Yeah.
Chair, if I may, if anyone has specific suggestions and details about those individuals, the best place to share that information would be in the Monday.com panelist nominations board that we've been using previously. Ideally, that's the best place, and or emailing Anna directly with the details.
Thank you. Jonathan? You're on mute. Still on mute.
Man, am I technically challenged? Going back to the comment that I should have saved for this meeting, we've heard from lots of parents who are understandably upset about losing their children. I don't think we've heard anybody who can speak for the children who were taken away for good reason and are better off for it. I'm not sure who that might be, but I think we ought to. I mean, if anybody has any suggestions, I'll think about it too, but it'd be nice to hear. I mean, there's got to be some cases at least where children's lives were saved or improved by being taken, and we ought to know about those cases.
And I just wanted to raise my hand, and I think one of the last speakers that we did hear from at I want to say the last meeting was an adult who had been taken into custody, and I mean, right. she acknowledged in her own comments that it probably needed to happen, right?
You're
but
right.
was
could get in touch with her.
We did have that, but to your point, we haven't had anybody that is a foster child or an adult that
Any other comments?
This is Catherine. Sorry, I had to jump in the car, but I agree with John's point. It would be good to get that perspective. And I was also wondering the same around actual social workers who are the first port of contact with families based on that sort of flowchart and have, been maligned in this process. And obviously we've heard, with overturning of staff and chronic underfunding and other things, but I don't know if it's appropriate, but I think it would be helpful to hear from social workers involved in this process, in addition to just the kind of director Cauley level, who's very much the administrator over everything, as opposed to those who are actually in the homes on a day-to-day basis. Like more firsthand experience from the state's perspective.
Mercedes, is your hand up?
Yeah, responding to that is I think we in Victoria can kind of chime in here afterwards. I think we did put out feelers for a handful of counties to come and speak. I mean, I think it was probably more the director of the counties, but I don't know that like an actual ground level supervisor would be authorized to come and speak. And what we have had testimony is people that have worked in those roles and are no longer working in the roles, right? And so I agree that it would be helpful. I just don't know how likely it's going to be to find somebody.
Okay, let's see. I saw someone's hand up. Was it Stephen?
Yeah, I think, but then Mercedes kind of hit my point, but I think, was it Amanda Wallace? Was that her name at the last hearing? Who literally was in that role. And honestly, that's what radicalized her to be this activist against it. So, I mean, her, obviously, I'm sure there could be some social workers who would share very different experiences, but that was why, and for me, her testimony was so compelling because she had actually served in that role and that had informed her beliefs on the topic. Anyway.
I mean, the same could be said for, I'm sorry for just jumping in, but Ms. Sotolongo, I'm mispronouncing her name.
Yes, agreed.
She was a DSS director and is now an appellate director. So that is very interesting, and I think speaks in and of itself.
Okay, let's see. We have judicial impact, foster care with a positive impact, and
we only have I was gonna say we only have room for like 2 speakers.
Well, that's why I was
so I think
I was listing those with suggestions so that we can narrow down to 2 that we can reach out to with the consensus of the committee. So is the judicial impact pretty consent? Okay, so we have that one. And Amanda Wallace, would she be someone that we would want to reach back out to?
I don't think we need to hear from her again, but
okay.
Yeah.
So who would be your second suggestion? Anyone?
It might be worth reaching out to the organizational speakers that we had and that represented foster families to see if they had any individuals that they could suggest that would be directly impacted individuals in that way.
With the positive aspect.
Yeah.
Okay, let's say I'm going to ask Victoria how she would like to proceed with this. If we have, I guess the one judge that we have the name and contact. Any organizational speakers, do we need to go in and say to you which ones, or will you just choose those agencies? I'm asking how you would like to proceed.
Thank you, Chair, for asking. And just for the record, also, I put in the chat, but I want to make sure everyone knows that a few months ago when we started outreach, I did reach out to 5 counties. 3 were the ones that had experienced state intervention, and 2 others were those that were brought up during public comment in earlier committee meetings. But I was not able to confirm representatives from those local DSS offices. But as far as the next steps for deciding how to proceed and gathering new testimony. I do want to request that if anyone has specific names of individuals or organizations, that again, you put it in the panelist nominations board or email Anna no later than a week from today on August 14th, because that will give her some time to do a similar process where we identify those individuals, send them the survey that we had initially sent everyone else, just to get a better sense of what they'd be able to speak to regarding this topic. And then at your next meeting, which will hopefully be end of this month or early September, then you'll be able to make a final decision on those, and we can reach out to schedule them to speak. But again, we want to make this level of the outreach very targeted, very pointed, since, as the chair mentioned, we would only have capacity for about 2 more speakers, just given the magnitude of the testimony that's already been received and the very short time frame for the remainder of the project. And so I've taken some notes on the suggestions shared today, but again, if there's anything additional, and if you have specific contact information for the people that were mentioned, please do share that directly with Anna as well. Any questions on that?
Any other perspectives missing that anyone would like to share? Because again, we won't have time. We'll take up the remaining 3 questions during our next meeting.
Yes, and to the chair's point, your next meeting will be a combination of everyone being on the same page with who those speakers will be, and also continuing to debrief on the other panels. And I see John's hand is raised.
Do we have a date for the next meeting? Next business meeting?
No. So Liliana will be in touch with a survey to schedule that. And since we have a lot of you on the call, it might be helpful, since you might remember that we initially had a tentative 5th panel date on August 30th. That was scheduled as a backup date in case one of the panelists from panels 1 through 4 was not available. We had a backup date, but that was not needed. It's not on your calendar now, but for those on the call, does August 30th still seem like a viable option for a potential meeting? Okay.
I know that's the Friday before Labor Day, right? Is that correct?
Yes.
Because I know that might be an issue for me, I know, but
Okay. Okay, it looks like it works for some of you. Either way, I think what we'll do then is Liliana will include it in a survey that she'll be sending out in the next couple of days. But we'll be aiming either for end of this month or early September, just to make sure any additional testimony is received, hopefully by mid-September at the latest. Any other questions? All right, and then once you have scheduled that date and you have that debrief discussion, then potentially you will have one other meeting with a panelist or 2. And that will be the end of receiving testimony. It'll be what we call closing the record. We also have the deadline for written testimony scheduled for next month on September 23rd. And so if any of these judges or other suggestions you're thinking about could potentially be a better option for written testimony, that can be part of the record as well. So please keep that in mind as another option. All right, that's everything I have, Chair.
I just wanted to ask if will we have questions prepared for written testimony, since we're trying to fill in, or what will be their guide, I guess is my question for their written testimony. Will they have a guide for questions?
That is something, if you have specific questions in mind, you can send those to Anna, but we would be sending everyone that survey that we used earlier on that had a couple basic questions regarding asking individuals what they would speak to regarding Rylan's law and if there's anything else that they would want us to know. So, but if there's anything more specific than that that you would want to include, please submit those potential questions to Anna as well by next week so she can keep those in mind as she conducts the outreach.
Thank you. Any other comments or questions? There being none. Let's see what time is it. Today's meeting is adjourned. Am I right there, Victoria? Okay.
Yes.
Okay. Today's meeting is adjourned at 1:24, and I want to thank everyone for attending and for your participation.